It's Conduit News Radio with Paul Harrell.
Literally, State Representative Jimmy Gazaway is walking from the parking lot into the studio right now. That's literally what is taking place. And so he's going to walk in this door any second. And we're going to talk a little bit about Issue 1. We're going to talk about the opinion and what happened with Issue 1 of the Supreme Court of the State of Arkansas. Issue 1 was thrown off of the ballot. And here he is, State Representative Jimmy Gazaway. Jimmy, let me get out of your way here, and you come over here. And, all right, so Issue 1's thrown off the ballot. Jimmy, first of all, how are you, sir?
I'm doing well, thanks.
Okay, good. All right, so I had no idea that our conversation, which took place a week ago, was going to be, I don't know. I mean, you did such a good job talking about how things were not, Issue 1 is not a good thing. And then, of course, the Supreme Court acts and throws it off the ballot. So what was your reaction when the Supreme Court did what they did?
From a substantive standpoint, I was pleased. I was glad that, that was not going to be on the ballot, so that it never had the opportunity to become law, because I thought substantively it was so bad for the people of Arkansas. But so I say that just because I was so opposed to the law. Mm-hmm. But at the same time, I almost wish that it would have went to a vote, because I think that the people of Arkansas would have rejected it. Mm-hmm. I believe that it was going to fail. I don't think that played any part in the court's ruling. I think from my reading of the opinion, I don't think that politics played a part in that. I think that they made their decision based on, what they thought procedurally was correct. But, from a political standpoint, I think that if it would have went to the people and the votes would have been counted, that it would have been defeated at the ballot.
I think you're right as well. But I think the Supreme Court, they did what they had to do here. By the book, this doesn't make any sense. They say, we conclude Issue 1 does not comply with Article 19, Section 22 of the Arkansas Constitution. The opinion goes on. First, the sections of Issue 1 are not all reasonably germane to each other. What does that mean, State Representative Jimmy Gazaway?
In other words, you had different provisions in the proposed constitutional amendment that pertain to different subjects. And even when you read the opinion, the proponents, or those who were there before the Supreme Court arguing in favor of, that it should remain on the ballot, one of the proponents said that it was about judicial power, and the other one said that it was about controlling the courts. And even the Supreme Court, I think, said that, or looked at it as if the two of you who are arguing for this law can't even agree what it's about. Is it about judicial power? Is it about how we regulate the court system? What exactly is this about? And I think the Supreme Court correctly ruled that if you include more than one subject in an amendment, the people can't really be for sure about what they're voting on. Mm-hmm. It's like a lot of the legislation that we see. There may be one thing in a bill that I really like and that I really want to vote for, and then they put that poison pill in there, as they call it, and that you insert another subject into the amendment or into a bill that I wouldn't agree with at all. Which makes you want to vote against it.
So it's bad enough when the leadership or some people put lawmakers in a position like that. We don't need to put the people in a position like that, where you say, this may be one really good thing that I agree with. I've just made up. Okay, what if you had a law that ended abortion? A lot of people would get behind that, but in the same amendment that you're added to, or you're asked to vote on, it also says that, hey, homeless people have a right to sleep on your front porch. It's like, well, I don't like that, but so which one are you going to vote for?
Exactly.
It's like, well, that's why we don't do this thing that's called log rolling. We're talking with State Representative Jimmy Gazaway. The opinion goes on. This is evident, meaning not all of the sections are reasonably germane to each other. This is evident upon comparing the first section of issue number 1 to its other sections. Appellate Barton argues this issue as follows. The connection between contingent attorney's fees in Section 1 and damages, capping damages at $500,000 in Section 2, is obvious. Such attorney's fees are contingent upon the amount of damages awarded, so those sections are reasonably germane to each other, and those sections both have a substantive interplay with Sections 3 and 4 because judicial procedure will govern the way in which the provisions of Sections 1 and 2 will be enforced in the courts. The Supreme Court opinion continues, without opining upon the relationship between other sections, it is simply untenable to assert that Section 1 is reasonably germane to Sections 3 or 4. Section 1 limits the rights to private parties to contract for legal services. Well, in Section 3 and 4, they broaden and diversify the legislature's ability to exert influence over judicial rulemaking authority. Those two are completely different things.
Exactly. That's exactly right. And so ultimately, I think they were correct in their opinion. One of the interesting things, about it, it was I believe it was a 6-1 decision. You had 5 who joined the majority opinion. You had Justice Wood, who voted with the majority, but authored a concurring opinion. And then you had Justice Womack, who dissented. Mm-hmm. And so I think that it was, I think the fact that you had 6 justices who all agreed that these provisions were just not similar enough to be included under the one rule test to put this before the people. Yeah. I think that says a lot to have 6 justices on the same side. Yeah. With only one dissent. However, if you read the dissent, I give Justice Womack a lot of credit. As I read his dissent, I thought, because Justice Womack's point in his dissent was, if you look back at what we've done in the past and you look at other constitutional amendments that have went before the people, many of these constitutional amendments have included subjects that may only be tangentially related to one another, and much like you could say this was, but maybe all fall under a larger, more general umbrella, but the individual sections may not be really that related to one another, and we've allowed those to go before the people. And so why are we applying such a stringent test to this proposed amendment when we've not applied that stringent of a test to others and actually allowed those to go before the people? And, I thought that he made a good point there, but I think this was the Supreme Court's way of saying maybe we've done that in the past, but we don't need to do that anymore. This is too much.
Yeah. By this definition of law, really, I think it's good because it should be applied to other more of these amendments. I mean, for example, convicted felon John Woods, his issue 3, certainly. I mean, you have your reforming ethics in the way they did, which was very strange. It actually hurt small businesses' ability to participate in the political process. But then it also finagled a way for them to raise their salaries, okay, and it finagled a way for the term limits to be longer, so people can stay in office. Now, if those aren't 3 separate issues, I mean, that should have never been voted on by the people.
And so that's exactly right. And I think Justice Womack even mentioned that in his dissent, that that was a proposed constitutional amendment that went before the people, and it included, on one hand, some provisions about ethics, on another hand, a provision about term limits, and that was allowed to go before the people. And Justice Wood, in her concurring opinion, what I found interesting about that was she basically said, I think she was agreeing with Justice Womack in that we've allowed a lot of things in the past to go onto the ballot that contain maybe more than one subject, but she said we can't look backwards. We can't go back and fix what may have been allowed in the past. All we can do is stop what we have now, and I believe that this contains more than one subject.
Yeah, and so I don't think. Let me ask you. Feel free to you don't have to speak for other people. I don't know what the rest of the legislature, the rest of your colleagues think, but I don't think they should be surprised at this outcome, because ultimately this is the court's power was at stake here, and so even if I think their ruling is correct, like legally, I think it's sound. But even if it was, hey, let's give this a little extra attention because this is about us, this is about the court's power. I don't fault them for that. They're an independent branch of government, and they need to assert their institutional authority over the legislature, separate but equal, over the executive. And so I don't think anybody should be surprised that we are here where we are now, because the legislature was trying to take power away from the court. Bottom line, take everything else out. They were trying to take power away from the court, and the court said, no, we've got the authority to strip this out of the people's hands, and we're going to do that. And I'm not surprised by that. I mean, I would expect any institution that had a respect for its legal authority to do exactly what they did.
Yeah, I agree. I don't think that I really don't think that the decision was based on the fact that the proposed amendment was an attack, you might say, an attack on the judiciary. I mean, I don't feel that that's the reason why they struck it down.
Well, certainly that's not what the text of their opinion says.
No, and I truly don't believe that that's why they did it. I believe that they did it because, we have rules about how constitutional amendments are to be proposed and submitted to the people.
Mm-hmm.
And one of those rules, as part of our Constitution, is if you're going to refer an amendment, a constitutional amendment to the people, it has to be about one subject. And they took that very seriously and stopped the practice that we've had in Arkansas in years past of referring amendments to the people that contain more than one subject, where you think you're voting on ethics, but you're voting on term limits. And, so for this particular amendment, you think you're voting on, attorney fee contingency contracts, when in fact you're voting on also damage caps, you're voting on the court rules and the ability of the legislature to make or amend court rules and changes to Amendment 80. I mean, it was very broad and encompassing proposed amendment.
Yeah.
It encompassed so many different issues, and so I think they made their decision based on the law and the Constitution, and not about the fact that the proposed amendment would have taken power away from them.
We're talking with state representative. You have something else to add?
Well, I was just also going to say, but I do think one of the important points and something that you said was an independent judiciary is vital to the functioning of our constitutional republic. I mean, you have to have an independent judiciary who is able to make decisions based on the facts, based on the law, based on precedent, so that our constitutional system works. If the judicial system and our judiciary is making decisions based on politics and on popular will, then we might as well not have a judiciary. The judiciary exists to uphold the law, uphold the Constitution, and I think that's what they did in this case. But if you insert politics into that decision making, then you have effectively destroyed the independence of the judiciary, which is a vitally important part of how our system of government is designed to work.
We're talking with State Representative Jimmy Gazaway. Obviously, this was a divisive issue. We're talking about issue 1 being thrown off the ballot. This was the bad tort reform amendment, as I call it. It would have done a lot of terrible things. Just a big victory for the people. I think that there's not even a chance now that you're not going to be able, to sue somebody and only be able to get $500,000, regardless of if somebody was negligent and you're maimed for the rest of your life or you're disabled for the rest of your life. I mean, that's a big win for the people. There were some members, and I know it's been divisive, in some Republican ranks, but there were some that when this decision immediately came out, Senator Trent Garner tweeted, "Hey, we're going to look at the budget. We're going to look at the court budget." Because they have done this, it's sort of a retaliation. We may cut the court's budget because of what they've done. Oh, you wouldn't support that kind of retaliatory action, would you?
Well, no, absolutely not. And Senator Garner was passionate about the issue, as was I. Senator Garner was on one side of the issue, I was on the other, and I think that was just a reaction on his part, due to his passion that he has on the subject. But no, and that's, I think, to your point, and also to the point that I was making, which is that the judiciary can't be beholden to threats of intimidation, of politics, of if you don't do what we want, then we'll do this to you. they have to make decisions based solely on the Constitution, based on precedent, based on the things that are before them, because that is the very essence of being an independent judiciary. And, you know, if they made decisions based on, well, if we do this, I think there's, you know, we may get our budget cut.
Yeah.
If we do this, you know, we may all get impeached, you know, whatever it might be. You can't, you know, that if those sorts of thoughts are occurring in the minds of the justices on the Supreme Court, they can't render fair decisions. And that's, you know, and so I do think that, you know, that does present a concern to the independence of the judiciary,
Yeah.
again, which is very important to how our government works.
What do you think about the concept of tort reform just in general? I mean, you know, there's some people that agree with the idea of tort reform. I mean, one of the big opponents of this issue one was Jerry Cox of the Family Council. You know, he's been going on multi-city tours across Arkansas, you know, trying to educate people. But he said on the show multiple times that he supports some aspects of tort reform. There are some changes that do need to be made, but issue one was not it. It was written by the nursing homes and everything else. So is there a way to, you know, have a tort reform that's, in your mind, you know, that's acceptable to you?
Well, I think that there is, and you know, many Republicans are for tort reform. I think there are reforms to our judicial system that could be made that would be beneficial. But this was not it. I mean, this clearly was not the right solution to a problem, if there is a problem that exists for some of the alleged reasons why we needed this law. So the idea of frivolous lawsuits, I mean, quite frankly, I don't believe our courts have a problem with frivolous lawsuits. I'm not saying that there aren't some occasionally, but the vast majority would never make it past summary judgment. The vast majority of any kind of lawsuit that's truly frivolous is not going to make it to trial. And if it is truly frivolous and it makes it to trial, you would hope that a judge or jury would not find, you know, in favor of the person bringing that type of claim. So I think, you know, if you're going to address that problem,
Yeah.
there are ways to address it. And issue one did absolutely nothing to address that.
That's true. That's true.
You know, you know, as I said, as I look, the word frivolous is not mentioned in the entire body of the text of what was issue one. And so, you know, how could it even purport to address frivolous lawsuits when it doesn't even mention frivolous lawsuits? It doesn't mention unmeritorious claims. And so one way I think that you do that is if you sanctioned attorneys. You know, you give judges power to sanction attorneys who file claims that are determined by the court to be frivolous. You know, maybe some type of sanction within the bar, you know, for a license action for somebody who files frivolous claims.
Make sure it's a real victim. I mean, do some due diligence. So I've heard stories of business owners, and you know, you got a grocery store, and you got people that, you know, go in the grocery store and they take some grape jelly off the shelf, and then they, you know, put it on the floor, slip and fall on it. Oh, boom, now you got your lawsuit, right? That stuff happens, you know. Now, does it get to court? Maybe not. Maybe you end up just settling with them because you don't want to, you know, there's that aspect too where a lot of this stuff is settled, and it's frivolously settled because they don't want to pay the court fees, the attorney fees.
Yeah.
So.
Well, and I understand that. You're talking, you know, I think the cases that you mentioned, you're talking about really pretty low-level cases that settle for, if they do settle,
right,
you know, probably don't settle for much money.
Right, true.
But what they did was they limited the upper level of the spectrum. I mean, they put a limit on the people who, and this happens, this is what really bothered me about this, is that these things that were affected by issue one happen every year in Arkansas. People become quadriplegics. They get burned in fires because they were ran over by an 18-wheeler and their gas tank exploded, and they're burned to the point that they're unrecognizable. They go through, you know, a year's worth of skin grafts and you know, and other medical treatment. People that become paralyzed and brain damaged because of negligence of another through no fault of their own. Those types of cases and those types of injuries happen every year in the state of Arkansas. And, you know, to limit a recovery of true victims, who are in need to be made whole. And that's why our civil justice system exists in the first place, is to try to make people whole who have been harmed, and to limit that at $500,000. And of course, that includes wrongful death cases where people have died as the result, lost their life as the result of negligence of another. To limit that at $500,000 is just immoral, in my opinion.
And we got to wrap it up here with State Representative Jimmy Gazaway. But one of the best points that you made last week had to do with the fact that Apple's about to be valued at $1 trillion, or it already is, and Amazon's fast behind them, and how $500,000, when we have all of these companies growing the way they are and worth billions and billions, and now we're getting into $1 trillion valuations, is insane. I mean, there would be literally, people need to understand, $1 trillion is $27 million a day for 100 years with money still left over.
Yeah.
Right? That's insane amount of money. Anyway, State Representative Jimmy Gazaway, I appreciate you being on.
Thank you.
It's always great to have you. Folks, we got to take a break. Back in a moment.